Okay, ladies and gentlemen. So now is the time for the roundtable discussion on the topic Enforcement of Arbitral Awards, Global Perspectives, exploring the challenges and strategies in enforcing arbitral awards globally, analyzing recent developments in the enforcement of arbitral decisions. And for this, I would like to call upon stage our first panelist, Ms. Aastha Chawla, Director at International Center for Dispute Resolution. Let's have a huge round of applause, everyone, for Ms. Aastha Chawla. The second panelist is Mr. Rishabh Malaviya, Counsel at SIAC's Secretariat. Let's have a huge round of applause, everyone, for Mr. Rishabh Malaviya. And the third panelist for the session is Dr. Moksha Kalyanram Abhiramula, Founding Partner at Dispute Resolution Hub, who's also our Powered by sponsor. Let's have a huge round of applause, everyone, for Dr. Moksha.
So to have an understanding of enforcements, now national, international awards have their own role, but when it comes to international awards, we give a separate category called foreign awards. There are challenges with respect to difference in jurisprudence. Question of jurisdiction is always the primary question which people ask when execution is to be either delayed or either to be postponed. That's the general focus which people put in. Now, with this background, there is a New York Convention which has always been talked of. So I just wanted to start my question with Aastha as to what are the impacts of this New York Convention and how things move in the international arbitration for New York Convention.
Thank you very much for the question. New York Convention lays down the scope of an arbitral award and under what grounds can an arbitral award be enforced or rejected. The grounds of rejection are mentioned in New York Convention. The grounds are very limited, and courts, especially courts which see international awards enforcement very often, are now more pro towards enforcement instead of refusing enforcement. That is the pro-arbitration approach that the courts are taking nowadays. It has been, we've seen this shift, especially in India for the last 10 to 15 years, that the courts are now taking pro-enforcement approach for arbitral awards. However, there are certain grounds under which New York Convention allows to refuse enforcement. These grounds are very limited, and it starts from the very basic, which is incapacity or an invalid arbitration agreement. So if the arbitration agreement from which the arbitral award arises, if that agreement itself is invalid or there is any incapacity, for example, the person who has signed the arbitration agreement did not have the capacity to sign it. In those cases, the arbitral award can be refused. But as is applicable for all grounds of refusal, the party who is resisting enforcement will have to showcase proof that the agreement was actually invalid or the agreement was not signed or there was any incapacity of the signing authority. So if such proofs are furnished to the court can and may refuse enforcement of such an arbitral award. The second would be lack of proper notice or a party was not heard. Now this goes to principle of natural justice, where every party has the right to present their case. So as an arbitral institution, it is our duty to make sure that the party had enough notice to present its case. So although all institutions have their own processes, but these institutions, the main agenda, the goal remains the same. It's just difference in doing things but they all meet the same goal, that the parties are being provided with enough notice to present their case. So how do we do these things? For example, we make sure that once a case comes to an arbitral institution, whether it's SIAC or ICDR, of course, there are different processes, but the other party is duly served with the notice of arbitration so that they can build their case, they can represent themselves, and they can refuse whatever the claim claimant has mentioned in its notice of arbitration. So these are certain cases where if a court is satisfied that the other party, which is refusing enforcement, did not get enough opportunity to present its case, then the court may and can refuse enforcement of such an award because it goes into principles of natural justice. Then if an arbitral tribunal determines something in the arbitral award which goes beyond their jurisdiction. Now, what is beyond their jurisdiction? Let's say a party claimed a declaratory relief. The arbitral tribunal can only decide on that particular declaratory relief. The arbitral tribunal, if goes beyond that claim or says anything apart from it, then the arbitral tribunal is going beyond its jurisdiction, and to that extent, to the extent that the arbitral tribunal is going beyond the jurisdiction, only to that extent the court can refuse enforcement of the award. Then the fourth and most important one for arbitral institutions is composition of the arbitral tribunal. If the composition of the arbitral tribunal is irregular or not as per the rules of the institution or as per the agreement of the parties, then the court can refuse enforcement. Let's say in an agreement, the parties have decided that the arbitral tribunal will comprise of will be a three-member tribunal. However, an institution, or if it's an ad hoc international arbitration, if the tribunal is a sole arbitrator, in that case, it is irregular composition of the tribunal. Unless, despite what is mentioned in the arbitral agreement, the parties, after the dispute has arisen, decide that, okay, we understand we had agreed to three-member tribunal, but now we think that the case can be resolved by a sole arbitrator and it will be more efficient and would save costs. In that case, if the parties have an agreement on that point, in that case it gets changed. And then the sole arbitrator's appointment is valid appointment, and in that case, the court will not refuse enforcement of this award. Now, the next 2 points that I'm going to mention are, they are based on which jurisdiction that you are enforcing your award, which goes to subject matter is arbitrable in that jurisdiction or not. This is a very contentious issue, and especially in India, I believe Rishabh will throw some light on it. Now, for example, and this is an IP conference as well, so IP disputes, there is still a gray area in India whether it's arbitrable or not. So let's say there was an IP dispute and the award was against an Indian party. The assets of this Indian party are in India. The winning party will go to India to get its award enforced, and when they apply for such enforcement, the court can say that this particular dispute is not arbitrable in India. IP disputes are not arbitrable, although it's a gray area right now. So in those cases, the courts can deny. And the second is, which is jurisdiction-specific ground, is violation of public policy. So if an award violates public policy of a particular jurisdiction, in those cases also the court can refuse enforcement of such an award. So these are 7 grounds under New York Convention in which the court can refuse enforcement. I think Rishabh would be enumerating case examples as well.
We are waiting to hear you.
Thank you, Dr. Moksha, and thank you, Aastha, for the introduction to the New York Convention. I think when you talk about enforcement of arbitral awards, it's also important to go back to first principles and understand what arbitration actually is, right? Because ultimately what you are saying when you agree to an arbitration is you are giving up the right to go to court. Now that's a very valuable right in most jurisdictions. It's a constitutional right in most jurisdictions. And if you have to give it up, the state, most states would want to regulate it very closely. And that's really the background as to why you need provisions or national laws on recognition and enforcement. Because arbitration, even though it's out of court settlement of your dispute, ultimately it needs the sanction of the court. It needs the might of the state behind it to actually be enforceable or to have any teeth. And that's really the background in which the New York Convention came about. A number of countries got together and agreed to a common set of standards which they would follow in recognizing and enforcing arbitral awards. And Aastha introduced and spoke about a few of those. But even within those standards, each country retains certain discretion in how they wish to implement those standards. And honestly, as a disputes lawyer, I can tell you that having a common set of standards doesn't really mean anything, because disputes lawyers will find a way to get out of those standards. And that's really where a lot of the jurisprudence around recognition and enforcement comes from. Now in India, when you talk about recognition and enforcement, there's two provisions that you really want to talk about, and both are quite similar. One is Section 34 and the other is Section 48. Section 34 is relevant when you're talking about an India-seated arbitration, which essentially means when the legal home of the arbitration is in India. Section 48 is when you want to recognize an award and enforce an award from a foreign jurisdiction. So for instance, if your seat of arbitration was in Singapore and you wanted to enforce the award in India against an Indian party, you'd look at Section 48. And now the grounds for refusal of enforcement are largely what Aastha described. And I just want to talk about a few of them in the context of India and the jurisprudence that's evolved around them. Now, Aastha spoke about lack of jurisdiction, essentially when a claim that the tribunal has dealt with is outside the jurisdiction of the tribunal. Now, in most jurisdictions, what courts would do is that they would conduct a de novo review of the tribunal's jurisdiction. Essentially, they would revisit that question in its entirety. Now, this is a bit of an exception to the other provisions, because a setting aside proceedings or a recognition proceedings is not actually an appeal against the arbitral award. There are very limited grounds on which an award can be challenged. But where the tribunal's jurisdiction itself is in question, the court would typically go into that question and decide it in a detailed manner. So in Singapore, they say they would essentially look at the matter afresh, independent of what the tribunal itself has found. And that was the case of PT First Media. Aastha also spoke about a very important and interesting provision about non-compliance with party agreement. And she gave an example of where the arbitration agreement provides for 3 arbitrators, but what is ultimately appointed is a sole arbitrator. Now, this would be non-compliance with the parties' agreement. And as she rightly pointed out, it could be a ground for refusal of enforcement, including in India. But let me tell you about some of the institutional provisions, for instance, that the SIAC has. And one of those is the expedited procedure. Now, the expedited procedure essentially provides for a process whereby the arbitration will be concluded within a period of 6 months from the constitution of the tribunal, and the tribunal itself will consist of a sole arbitrator. And this provision for a sole arbitrator will apply irrespective of whether the parties have separately agreed to a 3-member tribunal. So you may have a situation, in fact, where one part of the parties' agreement says that they want a 3-member tribunal, and at the same time, they've agreed to the SIAC rules, which provides that in certain circumstances, a sole arbitrator may be appointed. Now, interestingly, this provision has actually been upheld, including in India and in other jurisdictions like Thailand, to say that the institution can, in such circumstances, appoint a sole arbitrator, because by agreeing to the institutional rules, the parties have also impliedly agreed that in some circumstances, a sole arbitrator may be appointed, notwithstanding their general agreement on the aspect of the number of arbitrators to be appointed for that case. Now again, arbitrability is a bit of a question that was hotly debated in India for a long time. essentially it means that there are certain cases or certain subject matters that cannot be arbitrated. You cannot take it out of the court system. You cannot have a private settlement of those disputes. And examples of that may be, for instance, divorce proceedings. You can't really, in most jurisdictions, I think Australia may be an exception, but in most jurisdictions, including India, you wouldn't actually go to an arbitral tribunal for the arbitral tribunal to decide to grant a divorce or not. That is something that the court retains power over. So any agreement to that effect would not be binding, and any award in that respect, which is sought to be enforced in India, would not be recognized. Now, some of the important cases really about arbitrability in India, it starts with Sukanya Holdings, which, and Booz Allen actually, which spoke about subject matter arbitrability and certain categories of disputes that cannot be arbitrated. Things were clarified a bit more in Vidya Drolia, which was a couple of years ago, and which laid out the tests to see whether a particular subject matter is arbitrable or not. And essentially what it said is that when there is a subject matter which affects rights in rem, or rights which have an erga omnes effect, essentially where there are third parties involved, or where there is some state involvement, those rights cannot be the subject matter of arbitration. And essentially any award that is issued in that respect will not be recognized or enforced in India. There may also be certain subject matters that are subject to a particular legislation in India, for instance, the Indian Trusts Act. Now, trust disputes, by and large in India, are not arbitrable, simply because by express implication of the Trusts Act, those matters are retained to the civil courts, and therefore arbitration cannot take place in that respect. That's slightly different from Singapore, where I understand trust disputes are actually arbitrable. And I think the most hotly debated topic, actually more than arbitrability, is about public policy. Now, public policy is by definition a very nebulous term because it doesn't actually mean anything. Every state, every country decides for itself what its public policy is and on what grounds it is going to refuse to recognize an arbitral award. And in India, the courts have tried to define this for a long time, over a course of maybe 20 years, before we now finally have some clarity as to what public policy means and what the scope of the court's intervention will be when it's considering a matter of public policy. So first was the Renu Sagar case, I think it was some 20 years ago, and it dealt with an award that was arguably or allegedly in violation of the FERA, which was in force at that time, the Foreign Exchange Regulation Act. And the court found that a violation of the FERA would essentially be a violation of a fundamental policy of Indian law. And it said that public policy essentially means if there is a violation of the fundamental policy of Indian law, or if it's against the interests of India, or if it's against the basic notions of justice and morality. Now again, all of these terms are fairly wide and fairly nebulous. It's well intentioned in the sense that the court was trying to convey that it's a very high standard that the parties have to meet in order for an award not to be recognized. It has to be against justice, it has to be against morality, it has to, eventually the courts went into evolving the test of whether it shocks their conscience to see whether or not it's violating public policy. Now all of this, like I said, is well intentioned in the sense that the courts were trying to impress upon users that it's a very high standard that has to be met. But because the standard was so broad, suddenly every award was shocking to the conscience of the disputes lawyer that was challenging that award, which is why more clarity was needed. You then had the case of ONGC versus Saw Pipes, where they introduced another ground which said that if an award is patently illegal, it would be refused, or it could be refused enforcement. Now, when talking about patent illegality, essentially what courts then began doing is conducting a review of the merits of the award, which again is not permissible because a challenge to the award or an argument that an award should not be recognized is not an appeal on law. It is a very limited challenge in scope. It is very, very limited. So in 2015, the Indian Act was amended to clarify that firstly, the ground of patent illegality will not be available in the cases of international commercial arbitration seated in India or in the case of recognition of foreign awards in India. It's restricted to domestic India-seated arbitrations where all parties are Indian. And essentially, the 2015 amendment provided that an award would be against the fundamental policy, or it would be against public policy if it was obtained by fraud or corruption, if there is a contravention of the fundamental policy of Indian law, or if it is in conflict with the basic norms of morality and justice. And it was also clarified that none of this will entail a review on the merits of the award. So the limited scope of the challenge was still underscored. But we still had that case of what is contravention of fundamental policy of Indian law. Is a mere violation of any legislation a contravention of the fundamental policy of Indian law? And in the case of Vijay Karya, the Supreme Court actually said no, because contrary to Renu Sagar, in Vijay Karya, the court was examining the provisions of the FEMA, which had now come into force, the Foreign Exchange Management Act. And the allegation was that there was a violation of the FEMA in the arbitral award or by way of the arbitral award. And the court said that the FEMA is not a policing regulation, it's a fairly permissive regulation. And if there is a violation of it, it can be cured by the RBI. So if there is a payment in violation of the FEMA, you can apply to the RBI and the RBI can condone that violation. And because of that, any award that is issued, even in violation of FEMA in that case, was not found to be contrary to the fundamental policy of Indian law. So that's really how the scope of public policy has evolved in Indian jurisprudence. Also, speaking about India and the New York Convention, I just want to flag that the New York Convention allows state parties, it allows countries to have reservations or certain reservations to the applicability of the New York Convention, where they essentially say that they will not apply the New York Convention in certain cases. India has made two reservations. One is the commercial reservation, which essentially says that India will only apply the New York Convention on enforcement to awards that are commercial in nature, which is a fairly broad definition and would cover most of the commercial disputes that any of us would actually see. The second reservation that India has made is the reciprocity reservation, which essentially says that India will only apply the New York Convention in respect of an award which is made in a state which is also party to the New York Convention. So both states have to be a party. India and the other state has to be a party to the New York Convention for India to have to comply with the New York Convention. Now in practice, what this means is the central government has to issue a notification saying that XYZ territory is a reciprocating territory under the New York Convention, and therefore we will recognize the applicability of the New York Convention to that territory. So most of your territories would likely be by this point recognized, or most of the relevant territories in terms of the trade flows of Indian business would be recognized as reciprocating territories, including Singapore, I think London as well. The question mark for a long time was perhaps on the UAE, where the way I understand it, the notification has been issued but not actually notified. So the government wants to recognize it but has not actually taken the step of notifying that notification in the Gazette, which means that awards issued in the UAE may not have the protection of the New York Convention in India. And I think the workaround to that, from what I understand from my colleagues, is if you do have an award that's issued in the UAE that is seated in the UAE, what you'd probably have to do is get it recognized as a court judgment in the UAE and then try to enforce that court judgment in India as a court judgment and not under the New York Convention. So that's really how the Indian jurisprudence deals with recognition and enforcement of arbitral awards. And with that, I'll hand it back to Dr. Moksha for further questions.
Now, since we have an elaborate discussion on New York Convention applicability, reapplicability of the same, how it is recognized, just want to understand what role arbitral institutions make for making the enforceability of these awards which are issued under their umbrella to be more enforceable or more acceptable. Aastha.
All international arbitration institutions, they have one common goal: to make sure that we deliver enforceable awards. The entire process, let's say 12 months, 6 months, whatever amount of time goes into an arbitration proceeding, from the start notice of arbitration till the delivery of award, is null and zero if the award rendered is not enforceable. So the most important thing is to make sure that the award is enforceable. Now, how do we ensure that? There are certain things that arbitral institutions do with keeping in mind this common goal, and all institutions have their own way to ensure it, but of course they do ensure it. I'm sure SIAC has their own ways to do it. I'll talk about how ICDR makes sure that the awards are enforceable. So first is that we have a very robust arbitration rules, international arbitration rules. In these rules, we describe the procedure, what the parties have to follow. So, which gives parties a visibility of how the arbitral process will go once their dispute is filed before an arbitral institution, giving them a visibility of the entire process and what all steps they need to take on their end to make sure that the award is enforceable. The second and the most important thing that is the duty of an arbitral institution is appointment process of the arbitral tribunal. Because after all, institution, once the appointment of arbitrator is concluded, it's in the hands of the arbitrator to make sure that the award is enforceable with an oversight and supervision by the arbitral institution. Now, that particular appointment, what does ICDR do to ensure that we are appointing the right arbitrator? I'll take you through the entire process of the appointment. There are two things here. ICDR maintains a panel of arbitrators. We have around 800 international arbitrators on our panel, where the process of including these arbitrators on our panel is quite extensive. There's an entire application that they have to fill in, and they have to submit to ICDR. ICDR goes through the application in which there are certain requirements. You must have certain years of experience. You must have rendered at least a few international arbitration awards, and not domestic, international arbitration awards. These are certain requirements that we have for an arbitrator to apply on ICDR panel. These do not ensure that the particular application will be approved by ICDR. These are just qualification criteria. Once we receive this application, we have an internal committee as well as an external committee. We send these applications to an external committee, which comprises of well-known practitioners from a particular jurisdiction. For example, I receive 20 names of 20 applications from Asia. We have identified a few people who are a member of our external committee. They rank these applications out of 5. They give us their comments. We receive these comments, and we have then our internal review. All the top management of ICDR will sit together and will go through these applications, go through the reviews of the external committee and the comments that they have given, and we vet every application and then finally decide whether a particular applicant should be on ICDR panel or not. Now, once the applicant is part of ICDR panel of arbitrators, it's not the case that they will start getting appointments as an arbitrator, no. They will have to go through a mandatory training with ICDR, even if it's the topmost arbitrator you might be seeing in all international arbitrations. Even then, they will have to go through ICDR mandatory training to understand ICDR rules and to make sure that the award that they are rendering is in compliance with ICDR rules. Because process is another thing which if is not followed in a particular arbitral proceeding, the award can be challenged. Now, after this training is completed and they have gone through the mandatory steps, only then they are eligible to get appointed by ICDR in arbitration. So that's how we ensure that our arbitrators are fully trained and have all skills to render an enforceable award. Now I'll take you through what is the process of appointment of an arbitrator in a particular case. When a case is filed with ICDR, let's say the case comes to me as the case manager, the first thing that I will do is have an administrative call with both the parties we ask certain things in this administrative call, like what is the seat of arbitration, how do you want the, how many tribunal members, is it a 3-member tribunal or is it a sole arbitrator? Several administrative things are discussed in this administrative call, but the most important thing that is discussed is what are the qualifications that you're looking for in an arbitrator. Now the parties can say whatever qualifications, whether it's subject matter expertise, let's say it's a construction arbitration, then parties would say I want someone who is experienced in deciding construction disputes. Or let's say it's a German party involved and the certain documents are in German language. Then they can say that we want someone who knows German language, or whatever qualification on the face of this earth. Nationality, language, subject matter expertise, they can tell us anything. We will take note of these qualifications from both the parties. We'll enter these qualifications in our online case management system, where our system has the record of these 800 panel arbitrators that I talked about. These qualifications will be matched up with their CVs, and usually around 60 to 70 names pop up on my screen which have these qualifications. I'll go through these 50, 70 names and I'll go through these CVs and pick 10 best suited arbitrators for this particular case. I'll make a list of these names, attach their CVs to the list, and send it to both the parties. Now, parties have the right to either strike off the names that they don't like or rank in order of their preference of the leftover names, that the ones they like, and return this list back to me without sharing it with each other. Once the list is returned to us, we compare both the lists, and the topmost ranked arbitrator is usually appointed to the case. Now, what it does is it gives visibility to the parties who will be deciding their case. Second, so the parties are never surprised that how come ICDR appointed XYZ arbitrator, because it is actually their selection. Party has full autonomy to give their opinion in arbitrators' appointment process as well, even though they have given ICDR the right to appoint, even though we go a step ahead to make sure the parties have involvement in the process. The second thing that it does is that it reduces the chances of the challenge to arbitrator, because the parties themselves have ranked this person to be the arbitrator. So tomorrow the parties cannot say, no, I'm not satisfied with the appointment that ICDR has made. So these are certain things that we make sure that the right arbitrator is appointed to the case with the satisfaction of the parties. So tomorrow the parties cannot say that the composition of arbitral tribunal was not as per their satisfaction or not as per the process that they had agreed on. The next thing that we do is administrative support and ensuring procedural compliance. So always, if I am, or anyone from ICDR is the case manager, they will always be present during the arbitral proceedings. We do attend the hearing as well as the case managers. We have the entire procedural history. For example, there is a notice of hearing that I, as a case manager, sent to the parties 2 months in advance of the hearing. And suddenly, on the day of hearing, the respondents, let's say, does not appear. Now, in that case, the case manager can point out on XYZ date, the notice of hearing was sent, so we have given enough notice to the parties to present their case. So in this case, we reduce the chances of a challenge to the award or refusal of enforcement of an award. So that's how we give administrative support to the tribunal and to the parties as well. And let's say and this is not although going into enforceability of the award, but cost is a big consideration when we talk about arbitration. So an arbitrator's fee, when the arbitrator is spending X number of hours in an arbitration, they have to send us an invoice, which is itemized invoice, and where they have to mention 4 hours I spent reading the notice of arbitration, 2 hours I spent in reading the reply by the respondent. So the case manager in ICDR goes to the invoices and makes sure that there is no unreasonable billing done by the arbitrator. So these are certain steps that ICDR managers take to ensure that the arbitral process is smooth and an enforceable award is being rendered. Then the other thing that we do is review of the award. Once the arbitral tribunal has drafted their award, they will not send it directly to the parties, because ICDR, let's say they sent it to the parties, and later on the award is challenged. The parties will come up to us and say that, why did we trust you when the award was not being reviewed by you? So ICDR always takes a week and a half to review an award, draft award, submitted by the tribunal. We go through all the procedural history that is mentioned, and we have certain steps that we go through during the review process. And it's not just the case manager that reviews it. The case manager first will review the award, put in their comments, send it to the AVP, Assistant Vice President of Case Management. Once the Assistant VP gives their reviews on the award and their inputs, it goes to the VP of Case Management, and then the whole team, comprising of 3 people, will finalize the award, give our comments to the tribunal, and the tribunal can either explain certain things that we have pointed out or accept our suggestions, and only then the award is finalized and delivered to the parties. So we make sure that the award is crisp, we make sure that the award is following the procedure as per ICDR rules, and only then it is delivered to the parties. So these are certain steps that ICDR takes to ensure that an enforceable award is delivered, and later on there is no dissatisfaction to the parties. I think Rishabh will also like to.
Yes, thank you, Dr. Moksha and Aastha. I just want to highlight, again, taking a step back and, like I said, coming back to first principles. Now, as you would have seen from our answers to the previous question, the grounds for refusal of enforcement of or challenging an award in international arbitration are largely procedural, which is why there's so much focus on the procedure of the arbitration. It's not so much the substance, because obviously if you've appointed an experienced enough arbitrator, the substance is going to be taken care of. But procedures can vary across jurisdictions, across parties, and it is our job at the institution, really, in institutional arbitrations, to make sure that the procedure is as per as it should be, is what it should be. And it's why you have lawyers at institutions. It's why Aastha and I have a job at the institution, really, because you need the lawyers looking at the procedure. And like Aastha pointed out, our supervision, so to speak, our case management really starts from the very beginning, from the time of the appointment of the arbitrators. And similar to the ICDR, SIAC also maintains a panel. We try to comply with the parties' agreement insofar as possible. If the parties' agreement fails, the institution steps in to make the appointment so that you don't actually have to go to, for instance, the courts, as you would have to go in India should an agreement fail in an ad hoc arbitration. So it's the institution that steps in and adopts very careful appointment procedures. And it really goes to, again, the ground of refusal of enforcement, which talks about composition of the arbitral tribunal, which is why we pay a fair bit of attention to the appointment of arbitrators under the rules. But really, again, and like Aastha pointed out, the job doesn't really end there, because it continues during the duration of the proceedings itself. As part of my job, we supervise the case progress as well. So we're seeing that any potential lapses, for instance, in procedure can be flagged to the tribunal. For instance, the president of the SIAC Court of Arbitration retains the discretion to convene, for instance, a case management conference with the tribunal in case there are any obvious lapses, or if we feel that perhaps the conduct of the tribunal may not be as per what it should be, or may in a particular jurisdiction be seen as problematic. And in exceptional circumstances, and I've never seen this actually happen, But in exceptional circumstances, an arbitrator can also be removed by the institution. And I would imagine this is for the rare instance in which the conduct of the tribunal itself may jeopardize the enforcement of the arbitral award. And similar to the ICDR, of course, we have our own scrutiny process whereby every draft award, so any award that is issued under the SIAC rules must undergo the scrutiny of the institution, of the Secretariat. And it's one of the most significant roles performed by the institution. Now, the Secretariat, in the case of SIAC, consists of a number of lawyers qualified across various jurisdictions. I'm qualified in India, so for instance, if I'm looking at an Indian award or an India-related award or an award which may have a potential angle of enforcement in India, I have some understanding of what the courts may be looking at when they're looking at this award or when they're reviewing this award at the setting aside or enforcement stage. And any potential issues that the institution sees in the award will be flagged to the tribunal. So the idea behind the scrutiny process really is to enhance the enforceability of the award as far as possible. The institution's approval is required as to the form of the award. In terms of substance, of course, we're not looking to change the mind of the arbitrator. That's not our role, that's not our remit, and that's not what the parties agreed to. So we're not looking at changing the views of the arbitrators, but it's more about how the arbitrators actually arrived at that view. So for instance, let's say it's a voluminous case record and the tribunal, for instance, has not considered in the draft award one of the arguments advanced by the parties. Now, because the institution has sight of all those arguments, has gone through the pleadings, has gone through the evidence, and has gone through the submissions, the institution will flag to the tribunal that, listen, perhaps this is an argument you also consider and deal with in arriving at your decision, whatever that decision may be one way or the other. So that's part of the role that we perform. And to this effect, we also have a scrutiny checklist now, which essentially lays down certain steps that a tribunal must follow in all awards. So certain bare minimum standards that every award must comply with. And when a draft award is submitted to us, an arbitrator or the tribunal must check off all the aspects of the scrutiny checklist in submitting the award. This is aimed at facilitating the scrutiny of the award and for making it an even quicker process. Now, all of this, again, like I said, is with a view to enhancing the enforceability of the award. And at this juncture, I really want to speak about some of the statistics that may be of interest to the audience here. And I'm going to look at my notes for this because I'm horrible with numbers. Now, between 2011 to 2022, SIAC has seen 2,169 Indian parties involved in 1,372 disputes. These are India-related disputes, over 1,300 of them in a span of 10 or 11 years. Now, the total sum in dispute for these matters is well over 20 billion Singapore dollars. And between 2011 to 2022, not a single SIAC award was set aside or refused enforcement by the Indian courts. Now, this really goes to show you just how carefully the institutions look at enhancing the enforceability of the award. That's how careful we are about the procedures involved. And look, like I said, Indian jurisprudence on recognition and enforcement of awards and on setting aside of awards it's progressed a lot now, but historically there were some questions raised about it. And despite that, these are the statistics in respect of an institutional arbitration, which is really what the value add of the institution is. And again, like I said, that's how closely we look at enhancing the enforceability of the award. And that being said, I'd actually like to pose a question to Dr. Moksha, our moderator, about your perspectives on and experiences with enforcing awards and the extent of court intervention that you've seen in awards in India-related matters.
Oh, that's a nice question. Primarily, it is client's interest whenever any counsel works. So if you perceive that the client interest is not in line with the award that is seen or the award that is awarded to the client, then definitely grounds for challenges are searched, researched, identified, and posed. As Rishabh has rightly pointed out, it is not difficult for a dispute resolution lawyer to bring in further dispute. So we are here. But when the award is actually beneficial to my client, like as Aastha and Rishabh both pointed out, stating that It is selection based on election. We rank the arbitrator whom we want, and based on our ranking, that is, it was our election, which has resulted in selection of an arbitrator. So I will never bring in a case of prejury where I say this arbitrator has done a great loss to me. And prejury is the primary ground in which an arbitral award can be questioned, be it national, be it international. Now, after that, it is all on substance, which would already be covered in the entire arbitral award. And arbitral awards being challenged in countries is now minimal, but all said and done, having said that, the arbitral jurisprudence is still evolving. We are not at a stage where it is an evolved act or evolved jurisprudence where we see this is the solution for this problem. So it's still evolving stage, but we don't have challenges today so much that a national interest or party's interest is at stake where a challenge comes into picture. And Indian courts precisely are very systematic nowadays in evaluating whether an arbitral award, which is foreign in nature, be challenged or not. They're specific in two aspects. Unless there is an applicability issue. Unless I have some assets, we see this in IPR cases where there are assets. Now these are in digital form. You don't know whether that asset has its roots in India, whether you can actually enforce it or not. So when there is a question of confusion, in fact, courts also dismiss the petition, stating that fine, on the face of it, we see the award to be correct. We don't see that your grounds of challenge are so substantial that they can be questioning the award in itself. So they dismiss the petition. In the interest of justice, this is done. So I don't actually see the national courts are against foreign awards, but they are against those awards which are, they personally feel that it impacts some government asset or government security, which ideally I think institutions of ICDR as well as SIAC would have addressed it before the award has actually come. So that will not become an issue. That's my perspective of the case. Now, to take it further, I just wanted to further understand, having seen this enforceabilities, what other challenges you find which can be resorted through if someone, it's out of regular evaluation question, if someone really comes to ICDR and say, this is my problem, you suggest me with respect to the selection criteria. He or she, the company directly throws the ball in your court and says, I'm not aware of it, I cannot select. Now, what is the piece of advice that you would give to them? What type of advice you would give?
Just to clarify, this is not an ICDR arbitration. It's
an
ad hoc.
It's an ICDR arbitration which they come, and we have given them a question stating that these are the criterias in which I am giving you 10 different arbitrators. You choose, you rank, and then you come back to us.
Mm-hmm.
But then they say, we rank equally all of them. And classically, it may so happen that they rank equally all of them. Then what is the choice? How do you make it?
Well, ranking system is such that they won't be able to rank equally, but there are circumstances where this strike and rank does not work. In which case, ICDR makes administrative appointment, which means that the appointment is made by the ICDR. We go through the case, we select the best arbitrator for the particular subject matter, taking in account what the claim in dispute, because if it's a small claim dispute, we have to ensure that the arbitrator is not charging very high. So keeping in mind certain criterias, the amount in claim, the subject matter, the parties involved, we have to make sure that there is a diverse tribunal as well. We have a very famous JZ case in which the diversity issue was risen. So we have to make sure if the parties are from particular jurisdiction, they are well represented in the tribunal as well. So these are certain concerns that, and I'm just pointing out a few. There are various concerns which go through an institution's mind while appointing an arbitrator. In cases where the parties are unable to decide, or are unable to go through the list method, strike and rank, then the ICDR will make administrative appointment, which I think Rishabh would mention in his answer as well. And but in case of emergency arbitration, which we'll come to later on, but just touching upon this, in case of emergency arbitration, ICDR has only 1 day to make appointment of an arbitrator, because the relief sought is such that we cannot spend weeks in the list method. So in that case, we do administrative appointment only, which means that the ICDR will pick the most suited arbitrator who has the availability to render an emergency award within a short time frame. So these are certain things that we do when we making sure that the arbitrator is also available, has the diary which is not full with other cases, and can spend some time on the case. So certain things that go through for administrative appointment as well.
Your take on administrative appointments before we actually get into emergency awards.
Right. I think I can only really echo everything that Aastha said. Under the SIAC rules, most of the appointments, most of the default appointments are by the institution itself. We do adopt a list procedure from time to time, but the default mechanism is that the institution, the president of the SIAC Court of Arbitration, makes the appointment by herself. And that appointment process, the way it works is, let's say we have a case where the case management team needs to make suggestions for the appointment or for whom to appoint in that particular case, because the parties' agreement has failed or they've not managed to agree on, say, a common sole arbitrator. In that case, and like Aastha already pointed out, we'll take into consideration the subject matter of the case, the nationality of the party to some extent, because the nationality can have a role to play under some arbitral laws. We'll take into account the fees, the potential fees, and the sum in dispute in that particular matter. And based on that, we'll arrive on a list of a few names. That list will be vetted by the Secretariat, which starts with me, goes to my boss, and ultimately we'll put that list before the president of the SIAC Court of Arbitration. And from that list, the president will make the appointment based on any criteria that the parties have agreed and etc. One thing that we're also super careful about is checking for conflicts with potential arbitrators. So any arbitrator, before they are appointed, we will clear conflicts with them and make sure that they don't actually have any conflict or any disclosures to make in respect of the subject matter of the dispute or in respect of the parties. If a candidate is conflicted, it's very unlikely that they'll be appointed unless the parties have agreed to the appointment despite having knowledge of any disclosures that the candidate has to make. So again, like I said, it's quite similar to the considerations that go into the ICDR appointments. We're super careful about it, simply because, and going back to the New York Convention, that's one of the grounds where it can potentially lead to complications in the enforcement of an award.
Yes, Aastha.
I'll just like to add upon the conflict check that ICDR does. And it's a very relevant point, so thank you for raising that. ICDR does a preliminary check before making an appointment with the arbitrator, which means we send them the names of the parties and everything to the arbitrator to do preliminary conflict check on their end, on the arbitrator's end, whether they have represented one of these parties before or something. Once the arbitrator says that I do not have any conflict, we make the appointment. Now, the disclosure and conflict check doesn't end there, because after all, parties have to be satisfied with the appointment, and they should also feel that the arbitrator has no conflict. Now, what we do after that? Once the arbitrator is appointed and the arbitrator accepts appointment in our online case management platform, they have to fill a questionnaire where they have to answer certain questions, whether you have represented XYZ party, whether you have any relationship with the representative, with the counsel of XYZ party. So there are several questions like that, and they have to answer this. Once we receive these answers, we send it to the parties. The parties get 14 days to raise any objections to the disclosure given by the arbitrator. If within 14 days there is any objection to the appointment based on this disclosure by the arbitrator, then the challenge is decided by ICDR. If the 14-day time period lapses and ICDR has not received any objection from the parties, then ICDR confirms appointment, and that is the full and final appointment. The first one is based on only preliminary check, where the arbitrator does conflict check. The final appointment is after the parties have said no objection. So that's the disclosure and conflict check that we go through.
Precisely so. Now, I just want to understand, how does emergency arbitrations work, and when someone knocks the door of ICDR with an interim relief, how fast and how efficient is this relief given? Now, continuation question would be, what is the enforceability of that relief?
Thank you. This is always my favorite question, because I get the chance to boast about ICDR being the pioneer of emergency arbitration. ICDR was the first institution to introduce emergency arbitration back in 2006. And at that time, the only comparison that we could draw for immediate emergency interim relief was with courts, because at that time, institutions were not granting such interim reliefs. It was only courts that could grant such interim reliefs. And when a party files an interim relief application before the court, the cost in filing that application is none to minimal. So we did not know back in 2006 that institution can charge for emergency arbitration when we introduced emergency arbitration. So from 2006 until 2023, ICDR was not charging even a single penny for emergency arbitration. Of course, the arbitrator was charging for the time spent, but there was no administrative charge from ICDR's side. So emergency arbitrations were free until 2023, when we realized that all other institutions are charging for it, and we should also charge something, because a lot of time, effort is going into emergency arbitration. Now, what time and effort is going into arbitration, in emergency arbitration? When we receive an emergency arbitration application, ICDR has 1 day's time to appoint an emergency arbitrator. So, of course, we cannot go through the list method. We make an administrative appointment. As soon as the emergency arbitrator is appointed, we understand that disclosure and conflict check is very important. So we have retained the regular appointment process of disclosure and conflict check, even for emergency arbitration, which is the same that we do preliminary check before the appointment. Then once the appointment is done, there's a questionnaire the arbitrator has to fill. After the questionnaire is done, the party gets time to object to the appointment based on the disclosure of the arbitrator. Now, in a regular appointment of an regular arbitration, the parties get 14 days time to make an objection to the disclosure. However, in emergency arbitration, the nature is such that we have to speed up the process. In this case, parties get 1 day's time to make an objection on the arbitrator's disclosure. So once the appointment is finalized, the emergency arbitration goes through. Now, since 2006, and going back to statistics, and I echo Rishabh's concern, I also don't like statistics, I don't like numbers, but I must mention here that since 2003, ICDR has received 160 emergency applications. Although in India, emergency arbitration has gained recognition only recently, but in international arbitration, emergency arbitration has been, parties have been taking advantage of emergency arbitration for a long time. And out of these 160 applications, as of now, 1 application is pending before ICDR, and 159 applications have already been decided by ICDR, out of which 73 emergency arbitrations relief was granted either partially or in full. 41 emergency reliefs were denied, and parties settled 24 emergency arbitrations, which is quite rare, but we get very happy when there is a settlement. And 21 applications were withdrawn after submission. So this is the statistics part of emergency arbitration. When we come to enforceability, in certain jurisdictions like Singapore, emergency arbitral awards are enforceable, and Singapore is very pro of this concept. In India, there was always a resistance initially in enforcement of emergency awards, thinking that this does not fall under the category of final award. So earlier what was being done is the enforcement was granted through alternate mechanism, that is Section 9 of Indian Arbitration Act. And now the court in the famous Amazon case, which was a SIAC emergency arbitration, I will let Rishabh take this over. They recognized emergency arbitration, so now I think Rishabh would be the more appropriate person to talk about it.
Thank you, Aastha. And you're right in the sense that emergency arbitrations can actually be quite fun. The whole idea of emergency arbitration essentially is that the parties need urgent interim relief such that they cannot actually wait for the constitution of a regular tribunal, which is why they approach the institution and ask the institution to make an appointment within 1 day. The institution will make the appointment, parties can agitate the dispute, and within, at least under the SIAC rules, a period of 14 days, you'll have an order or an award. And it's quite popular, these proceedings. And as of May 2024, SIAC has seen 162 emergency arbitrator applications since the provisions were introduced. In the case of SIAC, SIAC was the first institution in Asia to introduce those provisions, and this was done in 2010. Now, of these 162 EA applications, I think, speaking as an Indian counsel at the Secretariat, I see just how frequently Indian parties resort to the EA provisions. And of the 162 EA applications, 94 of those cases have involved an Indian party. Now, this is second actually only to Singapore itself in terms of Indian parties. And of these 94 cases involving an Indian parties have typically been respondents. So 71 times they were respondents and 23 times they were claimants. And this actually tells me two things. Firstly, it tells me that the reason perhaps that Indian parties are resorting to emergency arbitration so frequently, notwithstanding the fact that SIAC has charged for emergency arbitrations for a while now, it's a matter of $5,000, yes, but it is an additional charge. But the reasons that the parties perhaps are resorting to these provisions is perhaps the perception, rightly or wrongly, that they cannot get equally effective or equally quick relief before the state courts. Now, drawing on my experience in Mumbai, I think to get a first hearing, even on a Section 9 application, could take a few weeks, which would defeat the entire purpose of wanting or trying to seek emergency interim relief, because a lot can happen in those few weeks if there is no protective order in place. And the second thing, those statistics about Indian parties, what it tells me, and like Aastha rightly pointed out, is that it's the Indian courts, and also the fact that Indian parties have so frequently been respondents in the emergency arbitrations, it's only natural that the Indian courts have had several opportunities to deal with the enforceability of the emergency arbitrator awards. And I think I can proudly say that it's the Indian courts that have actually led the way globally in discussing jurisprudence around enforceability of emergency arbitrator awards. And secondarily, I can also say proudly that most of those awards have actually been SIAC awards. And like Aastha really pointed out, that initially there was a question mark on the enforceability of EA awards in India. So what parties were then doing back then is that they were resorting to Section 9 of the Indian Arbitration Act, which is an independent provision whereby the Indian courts can grant interim relief in aid of the arbitration. So what parties would do is that they would get the emergency arbitrator award, they would take it to India, they would file a Section 9 application and ask the court to independently grant similar relief as was granted in the emergency arbitration provisions. Now, it's not a direct enforcement of the emergency arbitrator order or award, but it's an indirect way of achieving the same thing. And there were a couple of cases that dealt with this. The first was the Bombay High Court in HSBC versus Avitel, which was a set of 2 emergency arbitrator awards issued under the SIAC rules, whereby the single judge of the Bombay High Court and then the division bench of the Bombay High Court granted Section 9 relief in similar terms to what was granted in the emergency arbitration proceedings. I think then around 2012 came the Balco judgment, which really changed a lot of things in Indian arbitration for the better. But one perhaps gray area after Balco was the fact that Indian courts could then not actually grant relief in aid of a foreign arbitration, because Section 9 was deemed, Section 9 or entirely Part 1 of the Indian Arbitration Act, which includes Section 9, was held to be inapplicable in foreign seated arbitrations. This changed in the 2015 amendments, where Section 9 was made an exception. So Indian courts can now grant interim relief in aid of a foreign seated arbitration. And right after that, or shortly after that, was the case of Raffles versus EduComp, which was before the Delhi High Court. And a similar process was followed, whereby relief was, similar relief as the emergency relief was granted in terms of Section 9 of the Act. The third case was the Hotel Mumbai case. Now, Hotel Mumbai was actually a movie that was produced based on the 26/11 attacks in Mumbai, which were in a hotel. It starred Dev Patel and I think Anupam Kher. Now, the dispute in that case was the distributor of the movie alleged that the producers had violated their distribution rights in India because the producers wanted to stream the movie on Netflix. So what happened then is the distributors applied for emergency arbitration before SIAC. Emergency relief was granted, and the Bombay High Court did what it did in the previous cases and granted relief under Section 9 in similar terms as that granted by the emergency arbitrator. And then in 2020 came the case of Amazon versus Future, which, like Aastha said, really changed the landscape, and it recognized for the first time that emergency arbitrator awards are directly enforceable in India. Insofar as it is an India-seated arbitration, an emergency arbitrator's award will be treated on par. It will be treated equally to the order of an arbitral tribunal, and therefore it will automatically, under Section 17 of the Act, be recognized as an order of the court and will therefore be enforceable. Now, this leaves a slight gray area in the sense that Section 17 of the Act, under which the award was recognized in Amazon versus Future, does not actually deal with foreign-seated arbitrations. And therefore, the question is, what happens if it is a foreign-seated arbitration and an award needs to be enforced in that respect? An emergency arbitrator award needs to be enforced. Unfortunately, the Indian courts are yet to decide this issue. Perhaps the indirect route can continue to be used in the case of foreign-seated arbitrations, where you apply for a Section 9 independently and then use your emergency arbitrator relief as one of your grounds for seeking that relief and seeking relief in the same terms as the emergency relief. But perhaps that's something that will need to be addressed in the next round of amendments to the legislation as and when they come about. I think, like Aastha mentioned already, the situation or the case in Singapore is a bit clearer. It was always fairly clear by way of legislative amendment that a Singapore-seated emergency arbitrator award can be enforced in Singapore. And now, as per a recent judgment of the Singapore High Court, it's also fairly clear that an emergency arbitrator award rendered in a foreign-seated arbitration can also be enforced in Singapore. So that's really the long and short of it when it comes to the enforcement of emergency arbitrator awards.
What do you think we should improve in Indian jurisprudence in these lines? I think all of us will answer, but we'll start with you.
Yeah, I'm happy to take that. I think what's important to recognize is just how much progress has been made in the last 10, 15 years when it comes to India and arbitration law. So initially, if you go back to 2002, there was the case of Bhatia International, which was actually quite shocking to the larger arbitration community, because what the Indian courts essentially held over there is that they can also interfere in foreign arbitrations, which was a bit shocking because essentially they had no role, right, the Indian courts, to interfere in the foreign arbitrations. But Bhatia was also misinterpreted to a great extent, because what the court was trying to there do is say that they wanted to aid and support even a foreign arbitral process. But that, of course, disputes lawyers being disputes lawyers, they twisted that rationale into arguing for more and more intervention in foreign seated arbitral awards. That is what was changed in Balco. That was then subsequently modified, and the legislation has been updated in 2015 and 2019. We've seen some very, very pro-arbitration judgments from the Indian courts, the Indian Supreme Court, and Amazon versus Future is just one of them. It's, like I said, in terms of emergency arbitration, India is actually leading the way in terms of recognizing and enforcing emergency arbitrator awards. And I think if we stay the course, if we continue, we're on track really for everything to actually be okay in terms of Indian arbitration, because the courts are doing a good job now, in my personal view.
Your views, Aastha?
I echo Rishabh's suggestions, and I think the courts are now taking a pro-arbitration stance in certain jurisdictions more than certain others. However, if we understand that international arbitration is a global perspective, as the name of our session suggests, it is global, and all jurisdictions should follow the same parameters for enforcement, the same parameters for challenge. It will make much of a difference, because I think, I'll give you this just one example where I face problem, and I've been facing this problem since I wrote my thesis, which was seat of arbitration. So just one particular example I'll share, which points how different jurisdictions work differently, which in effect is detrimental to the arbitral awards enforcement. Let's say there is an arbitral award which was seated in UK, and the party, the losing party assets are in India. So as per the seat, the challenge will go in UK courts, and the enforcement being, assets being in India, the enforcement will go in India. Now let's say the subject matter of this award is something which is not arbitrable in India, and it is arbitrable in UK. Now the UK court, if a challenge is filed before UK court by the losing Indian party, the UK court will dismiss the challenge and will say this award is fine. There's no ground of challenge. Now the other recourse, now the Indian party has to resist enforcement in India when the winning party files for enforcement. Now when the winning party is filing for enforcement and the subject matter of this arbitral award is non-enforceable, the Indian party will definitely take this ground and resist enforcement, in which case the Indian courts will say that and in most likelihood would say that as per Indian law, this is not an arbitrable subject matter, hence we cannot grant enforcement. If that happens, the two jurisdictions are not on the same page. So I think if the certain jurisdictions are right now falling short, and they are taking steps to reach there, they are developing their jurisprudence, but it will take us some time to reach there. So when we reach all at the same level, I think it will be much easier for international arbitral awards to be enforced. And that is what we should aim. All jurisdictions should be at the same page. That's what I should.
So I am more focused on sensitizing jurisdictions since law is sensitized. With this, I think we end the panel discussion. Any questions we are willing to take, or we are happy? status?
I mean, I'm happy to give some preliminary thoughts, really. Kabir is also a senior from college, by the way, so it was nice to bump into him before the session. But I think from an institutional perspective, and like Aastha mentioned earlier, what we'll really focus on is trying to have on record as far as possible that the party was served at all points in time. The party was served when the notice was filed. The party was served when the arbitrator was appointed. The party was given of refusal of enforcement. So we'll try to show, at least from an institutional perspective, and we'll flag to the tribunal that, listen, even in your award, just talk about and mention how that party, the non-participating party, had adequate notice of the proceedings and was given a full opportunity to present its case. So from an institutional perspective, at least, that's what we do to make sure that the arbitration proceedings are not stalled unnecessarily. And at the same time, you also have to balance it with the efficiency of the proceedings. We cannot not have the proceedings. The proceedings cannot come to a halt just because one party doesn't want to participate. So that's really the balance we try to have between giving a party adequate notice and also getting on with the proceedings. Once it goes to the courts, of course, I think Dr. Moksha may have a bit more to add in this respect, unless Aastha wishes to add a bit more. Correct.
Okay. Small, a bit of light in what is being discussed. If I were in your place where I am so if I were in your place where I'm on the suffering side, where it took all steps. I was happy to receive an ex parte order. I appreciated the institution involved, but still I'm not able to enforce it. The first thing what the execution petition which is filed has to be addressed is we upfront mention this is an ex parte order which is received by us. Now, in common practice, the moment we see an execution petition filed, immediately we expect stay being asked by the other side. Now, when there is an ex parte order, we don't see the party coming for this order also. Now here, most of our judges are inclined not to pass orders because they don't want execution to be ex parte. This is what we have seen in the courts. Now, one way we can represent on a regular basis to the judge and then convince him that time is essence of justice and justice cannot be delayed. The second way is you can move the higher superior court stating that there is an ex parte order received, there's an execution petition filed, that is also ex parte, parties are not attending. It is just and proper for giving a direction to see that the ex parte order is executed, when the execution petition is executed. So the superior court will give a direction petition allowed. Based on that, you can come to the lower court where the attachment order or a relevant order is asked for execution and see that the execution petition is allowed at the lower court. But that's what we tried and that's what happened. But if I were on the other side where it is difficult for serving and the person is not coming, that's in my favor. I am as happy as before.
I'll just add one short thing in addition to what Rishabh and yourself have already mentioned. Giving notice is one thing. Making sure that the ex parte award captures all procedural history is another. So if the arbitral tribunal has not captured the history, being a counsel, you can actually pinpoint that. Although both of us here would already do that, so you don't have to. But if it's not by any chance, let's say it's an ad hoc arbitration, then please make sure that the arbitral tribunal mentions that on XY day notice was given. And there's one line that we make sure that is there in ex parte cases is that all necessary steps were taken to serve the party so that everything is clear and the court knows that the tribunal has taken all steps.
So we don't see that challenge in institutional arbitrations. It is addressed, dates, steps, everything is mentioned before the award is finally pronounced. That we have seen. But other side, as you have rightly pointed out, for ad hoc arbitrations, we have the issue. Now it's for the wisdom of the arbitrator at that time.
I think also if I set aside my neutral institutional hat for a second and dust off and put on my disputes lawyer hat from my litigation days, maybe in legal theory what you'd want to do is maybe try going after the related entities of the evasive respondent, try, I don't know, piercing the corporate veil. There are limited circumstances in which the execution court can do that. It's very difficult to do, but I mean, you might as well create some trouble for the other side if you're in that position, I suppose. But again, as an institutional representative, I can't really advise any party on doing pretty much anything, so take that with a pinch of salt. This is purely legal theory on my part.
I didn't want to get into that, considering our sensitive position.
It was great sharing the dais with you, and I really enjoyed the discussion. Thank you so much for being with us.